2012 and 2010 nominee for the U.S. House of Representatives against Betty McCollum in the 4th Congressional District in Minnesota. And today I want to show you inside the world of election law and who's really running the show when the Democratic Party runs in the 4th District in Minnesota and probably in most of the other districts which they control in the country. I have here a response from Betty McCollum through a lawyer to the Minnesota Supreme Court in an elections contest which I've filed and which has been ferociously blocked by Democratic officials in the state of Minnesota. I want to read how they defend kind of a quota system, agenda quota system that they are knowingly, openly running in the state of Minnesota, and especially hits hard in the 4th and 5th Congressional Districts. That's in St. Paul and Minneapolis, the metro area of Minnesota, where they maintain a safe district. And I also want to show you how they can suppress free speech and political expression in order to get their people in Washington, where, as we've seen in many cases, certainly in this case of Betty McCollum, she sits there and really does nothing about the problems of the country. So I'm going to read from this response of hers to the Minnesota Supreme Court. By order of this court dated December 26, 2012, Gildea, Chief Justice, the named respondents herein were authorized to serve a written response to the instant petition, that's my petition, along with supporting materials no later than January 14, 2013, which response is to be limited to the question of dismissing the petition without trial based upon the grounds of Laches, mootness, and or failure of the petition to state a claim upon which relief can be granted. The following response of Congresswoman Betty McCollum is hereby served and filed. Here's part one, in which Congresswoman McCollum argues that the instant petition should be dismissed without any further proceedings on the basis of doctrine of Laches, the doctrine of Laches. Now this is prepared by her attorney, her law firm, which is Weinblatt and Gaylord, and Alan Weinblatt, who is an experienced Minnesota elections attorney, has prepared this. Laches is an equitable doctrine which applies to prevent one who has not been diligent in asserting a known right from receiving relief at the expense of one who has been prejudiced by the delay. That cites Clark versus Reddick, Minnesota Supreme Court 2010, then another Minnesota Supreme Court case 2002, Winters versus Kiffmeyer, and finally a 1953 case from the Supreme Court, Aronovich versus Levy. Now in the instant case, he argues, petitioner knew about the Secretary of State's denial of his request for email addresses long before the general election. Now this, by the way, is false, as an aside. Likewise, he knew about the DFL policy of encouraging women and minority political participation long before the primary. It would be unfair to Congresswoman McCollum and to the citizenry as a whole to allow petitioner to proceed with the instant petition after having sat on whatever rights he thinks he might have for these many months. The DFL Constitution and bylaws, which encourage the minority and women participation policy, have long been a matter of public record. If petitioner objected to these policies, he could easily have found their specifics by resort to the DFL website www.dfl.org. His long delay in commencing this proceeding, baseless as the petition is, should not be countenanced. While Congresswoman McCollum has no legal control over the actions of the Minnesota Secretary of State regarding its release of email addresses, or over the DFL in its policy of encouraging political participation by women and minorities, the fact is that petitioner gave her no pre-election notice of his perceived complaints so as to offer her a chance to consider or act on them. Likewise, his failure to commence this action prior to the DFL party caucuses, conventions, and primary renders application of the doctrine of Laches particularly appropriate. The DFL was given no opportunity to address this alleged issue until long after its primary. Finally, the fact that he now seeks to overturn the result of a fair election after the fact and without use of proper legal process is prejudicial and unfair to the state's citizens as well as to the congresswoman. This court has repeatedly stressed the need for diligence and expeditious action by parties bringing ballot challenges, citing another Minnesota Supreme Court case from 1992 called Peterson v. Stafford. Petitioner's delay of many months in bringing his claims to this court is unreasonable. Granting the petition or even ordering a trial or granting any relief would be inequitable, costly, and unfair to all respondents and to the general public, even if it had any legal merit. The petition should be dismissed for that reason alone. Well, I do want to say that this procedure of an election contest, as well as the procedure at the Minnesota Supreme Court, are governed by statute. They're not governed by the common law. And there's no torts here. It's simply a statutory right, and it's instated by the legislature to be followed strictly and only defined by statute to achieve statutory goals that do protect all candidates and all the voters of Minnesota. And I would also note that I'm appearing in this case as an eligible voter, that is, one of the general citizenry, as well as the nominee of the Independence Party for Congresswoman McCollum's position in 2010 and 2012. And I will go on and introduce some of the other sections so that you can see inside the elections process and who really controls the elections. McCollum says she wants to fight for voting rights, but her party setting quotas for blacks and whites. She says she's representing all of Minnesota, but she really represents a Democrat quota. Up here we've always talked about integration, but today we're spreading quotas all across the nation. So instead of an intelligent conversation, the Democrats use cynical manipulation. Make it count. Let the voters govern. Our democratic system makes you the sovereign. Any kind of gender or racial steering is just another form of social engineering. We need a social system that's just and fair. A quota system just gives you a musical chair. The Democratic Party doesn't want your idea. They just want you to sit there for the world to see you. And when the party's over and they go back to work, you get to see Keith Ellison go totally berserk. He's calling his opponent a low-life scumbag. You know that's just a lot of political humbug. Make it count. Let the voters govern. In our democratic system, you know you're the sovereign. To close the unemployment and learning gap, you don't just hire performers to sing and rap. You've got to get employers to make some jobs, not smiling politicians and their adoring mobs. Does anyone even know where jobs could really come from? Well, it's not from Keith Ellison or Betty McCollum. I heard a Republican talking enterprise zone. Now, it's not a bad idea, and he's not alone. An enterprise zone might make things happen. Let everyone join in and don't leave anyone napping. Make it count. Let the voters govern. Our democratic system makes you the sovereign. I'm not a Republican, not a Democrat. Don't have a safe seat, not immune from defeat. I'm running for my office and I'm not standing pat. My congressional district stuck on Democrat. I want more economic development. I'm running for the House as an independent.